With us now to talk more about this is Danny Cevallos, criminal defense attorney and an MSNBC legal analyst, and George Grasso, a former New York City judge who is also a veteran of the New York Police Department. It's great seeing you both. Danny, let me just start with you. What do you see in these newly released documents in the Mar-a-Lago case?
I think there's a lot to be read in here. I mean, it's many pages of stuff we hadn't seen before. I mean, taking a step back, a motion to dismiss the case for selective or vindictive prosecution, that's always a long shot. I've filed these maybe once or twice. They rarely win because when you think about it, all prosecution is selective. All prosecution is discretionary. A prosecutor looks at a set of facts and says, I'm going to go after this guy. I'm choosing not to go after this guy. It's really hard to show. When you look at the test for selective prosecution, it uses kind of nebulous words. Like, can you show the prosecution was in bad faith? Well, bad faith means a lot of different things to different people. And since all prosecutors, whether federal or state, have limited resources, they have to pick and choose where they prosecute. That's the essence. That's the nature of the criminal justice system. So does Donald Trump have a stronger argument than most? Maybe, because he's a politician and maybe the most divisive political figure in American history. So you might have something there. But all in all, I'm not even aware of a selective prosecution motion that I know of saw firsthand somebody winning. So it just doesn't happen very often.
You know, George, the judge overseeing the classified documents case has now ruled on a series of motions. Is it unusual for a judge to wait a long time on ruling on motions?
Well, I mean, it does appear to some extent this case has been slow walked, but I don't have information on exactly what the issue she's trying to deal with is, but it doesn't look like she is prioritizing getting this case to trial before the end of the year. That's for sure.
No fast track on this.
Yeah, well, can I say something about it? Because in fairness, Judge Cannon has been criticized, and I think the criticism is fair about the speed at which she manages her docket. But it raises a question. Should these judges in Trump cases be thinking about the election, or should they treat every case as they would any other case? Obviously, they won't. For each judge, it's the most important case they'll ever hear in their entire career.
So if we look at taking away the political aspect of it,
right,
is it unusual that a judge waits this long to decide on motions?
Well, when you read Judge Cannon's order, it's not like she made this decision to put off the trial date by fiat. It's not like she just did it arbitrarily. There is some justification in the order. Where I think it's fair to criticize her is that she lists, I think it's about 14 different motions and matters that she has to hear. Some of them are on the same day, but a fair criticism is that she's just taking too long to do it. But one of the things that especially federal district court judges enjoy is near complete power over their own schedule. And I've heard people suggest that, well, she's a new judge. Maybe she just needs more time to think about these things. Fair enough. And I think the criticism is fair that it's not moving as quickly as it could be, as other judges might handle it. I'm sure, Judge, you can think of judges that would just race through these motions and decide them a lot faster than Judge Cannon.
Yeah, I wanted to, Judge, your thoughts on that. What Dasha was bringing up about the fact that in one of these newly released documents contained a policy statement on the use of deadly force while executing a search warrant. The FBI has said that that is standard process and standard procedure. Is that what it is?
I think it's basically this whole issue on the deadly physical force is basically what I would call a red herring. It appears that this is standard operating procedure and standard language used by the FBI, if that's true, to try and take it out in like a New York Post article and make it appear that this standard was singled out for Donald Trump, I think is kind of unfair to the FBI.
And Danny, I mean, the FBI said that they didn't add anything. They didn't subtract anything, but they didn't add anything to it.
Yeah, these documents, if you deal with these documents, whether at the state or federal level, they are full of boilerplate language. There is so much cutting and pasting going on in the criminal justice system that these are also often forms that are filled out. In fact, we refer to some of these forms in the federal context, at least. And by the way, here in New York City, you don't refer to a form as a police report. You call it a 302 in the federal.
Right.
These are to show that these are so formulaic that you literally print them out or fill them out now on a computer, and they are that form that is used. And they always contain that boilerplate language that as a lawyer or a judge, you kind of speed through it. You don't spend too much time on it. So this may be a bit of a red herring. I have to agree.
And Danny, turning now to the New York hush money trial, what did yesterday's charging conference tell us about what the jury instructions could look like?
So I was there. And
You've been there quite a bit,
I've
right?
been there every day.
Every day.
Every day. So I was there for the charging conference. And once again, it shows just how fair and measured Judge Juan Merchan has been. I cannot emphasize that enough. In particular, there's a major issue that Judge Merchan has not actually decided on yet that could be quite crucial. It's the issue of cause. Did Donald Trump actually cause the alleged falsification of business records? The DA was looking for kind of a broad standard, just if he acted in a way that could have led to the falsification of records, then that would be enough to go to the jury with that. Obviously, the defense was looking for a more restrictive approach. And in fact, it seems to me, and there's not a final ruling yet, that Judge Merchan is taking that under careful consideration and may require evidence to be presented to the jury that Trump in some way acted or approved on a specific document before the people could justify the falsification of records charge. Now, in other areas, he went with the people. I just make this one specific example, which I witnessed firsthand, to just call out the demagoguery against Judge Merchan, defending Trump, bringing in people from all over the country, a lot of VP wannabes, attacking the judge personally. The judge is biased. The judge is corrupt. We all need to recognize this for what it is. This is not an attack on the judge. This is an attack on the rule of law in this country. And it's certainly not justified by the judge's actions and rulings that I've seen.
George, using the fact that you have been there every day, and Danny actually talked about this yesterday, when Judge Merchan, in that moment where the star defense witness was on there, he cleared the courtroom. In your experience, has that happened?
No.
Zero?
Zero.
Yeah, it doesn't happen.
What was that like?
It was kind of shocking. It was almost like a little electrifying. At first, everybody, including me, didn't really quite understand what that meant. You know, we all supposed to get up and leave. And then the officers were put in a tough spot because, you know, a lot of people from the press, not a lot, but some were like refusing to leave. You know, I have a First Amendment right to stay. We can understand that. But then we were asked to leave. But interestingly, defendant Trump's entourage, those sitting in the first couple of rows with him, I believe, were permitted to stay. And everything that the judge said to Mr. Costello, who was the witness involved, was on a publicly reported record.
So all the years you were on the bench, 0 times.
In terms of clearing out the courtroom to deal with a specific witness, for me and to my personal knowledge, the number is 0.
And Danny, so let's talk about what we can expect next week. Closing arguments are expected sometime in the week. What do you think both sides have to do to strengthen and conclude their case?
Okay, the prosecution's path is clear. They've established beyond a reasonable doubt the transactions, first from Cohen to Daniels and then from Trump to Cohen. The challenge they have is proving intent. Not that they don't have it. They have evidence of Trump's awareness of these payments, maybe arguably beyond a reasonable doubt that Trump may have been aware of these, at least enough for a jury to find. The defense's argument is going to be legal. There's going to be some factual element to it. Number one, Michael Cohen's a liar. Big surprise. We knew that was coming. But in addition to that, I expect you're going to see an empty chair defense. Where was Alan Weisselberg? They could have called him and they didn't. His handwriting is literally all over the exhibits. That may show that this was an Alan Weisselberg, Michael Cohen production and not Donald Trump. And then thirdly, they're going to focus a lot, maybe not so much on the evidence we heard from witnesses, but maybe a lot about what we heard yesterday in the charging conference, all that arcane philosophical discussion of intent and purpose and willfully, because I expect them to make a really strong argument that they failed to prove beyond a reasonable doubt that Trump had the requisite awareness that he was committing a crime, or however it's going to be phrased ultimately after the jury instructions are finalized.
Danny Salas and George Grasso, thank you both so much for being with us this morning. Really appreciate it.
Pleasure's mine.